your client on any bail or not?
They are, most of the accused are out on bail.
I'm asking.
The accused number one.
Thank you. Who is appearing for accused number 2? Please, please, please repeat your name.
My lord, sorry. My God, you stop. What she says will not be recorded.
Did you say your surname was Mahalo?
It's Mohammed, my lord.
Mahano.
Yes.
And your initials?
It's M.
FM.
M.
He's
Assisted by counsel M. Mhlanga.
Mslanga.
Yes. Lord, my lord.
Accused number 2 is also on bail.
I believe so, my lord.
And accused number 2 is present in court.
Yes, sir.
Thank you.
And that accused number 2 is not ready to proceed, my lord.
He is not ready to proceed.
No, we're not ready to proceed.
Why not?
My lord, the accused applied for assistance from legal aid, and his application was declined, and therefore it's only on the 6th of April that my office came into record, and we were only able to brief counsel, and he was able to appear on the 11th.
But you say Advocate Mslanga is not ready to proceed.
She's not available. not have time to seek any alternative advocate. He was the advocate.
I'm assisted, my lord, by the continual governor.
I'm sorry to interrupt you, sir. Your initials and surname?
LM, and my surname is Hodes, Hodes. My senior, and my junior is Miss Governor. Her initial was T Governor. And we're instructed on behalf of accused 3, 4, and 13, my lord.
Yes, I have it,
Our
thank
attorney
you.
of record is Victor Kwashu of the firm DNA Incorporated. He's unfortunately absent as a bereavement. His mother passed away on Sunday. He's been at every other pre-trial and appearance relating to this matter.
Thank you, Mr. Hodes.
My lord, may I state our position on record?
Yes, please.
My lord, and it was on the national media that predicted that this matter would not run. We are ready. On behalf of all 3 accused, that we were informed by my learned friend for the state that the matter will not be running. I have a full account of everything. If I may just take your lordship through a brief summation.
Yes.
Because it appears that your lordship isn't favoured with the enormity of this matter, and The attorney who appeared for accused number 2 referred to 126 pages, which shows...
Mr. Houders, I'm fully aware of the enormity of this
It's
matter.
126,000 pages, my lord.
Yes,
26,000 pages, my lord.
yes, and there are more than 90 state witnesses that will testify, and there are almost 100 charges, and there are thousands of documents that will be handed in. That at least I'm aware of.
Perhaps I can be of assistance to this honourable court. Accused 1, 2, 3, 7, 9, 11 and 12 were arrested on J50 warrants, my lord, as far back as the 30th of September 2020. Bail was set, they were in custody overnight, bail was then set. There was an exchange of correspondence on behalf of accused number 13, whom we also represent. And on the 10th of November 2020, my lord, a J50 warrant was secured for accused number 13 and shown to us. He was in turn handed over, my lord, and the formal bail application, because it's Schedule 5, then issued on the 13th of November 2020. He was then also released on bail. So all of our clients, our two human clients, and obviously the company doesn't come into the picture, are on bail, my lord. There have been numerous, my lord, I can go through it, it's quite obvious, appearances and postponement and pre-trial conferences, exchanges of correspondence, and I can take the lordship through all the different steps that I don't believe is necessary. I can go forward, my lord, to this year, if I may, because that will be of assistance. So, my lord, there was an exchange of correspondence from the DPP's office in December of 2024 relating to the appointment of a judge from an outside court. And there was a response by the DJP in Behelis to that letter on the 17th of December 2024. And this culminated, my lord, in a pre-trial conference that was held virtually on the 20th of January of this year. And that's where I think we can start from, if you don't mind, my lord. At that virtual pre-trial, my lord, I record that the accused 9, 10 and 11 were absent. Not that they didn't have legal representatives, my lord. They didn't even appear to be aware of the pre-trial. So they weren't in attendance at the pre-trial, and that was recorded in the pre-trial. There was then a debate pertaining to that letter, my lord, and it was explained by the state that it was sent in good faith. And the state recorded there and then that they were ready for trial, but they had caused another issue to come to the fore, and that there would be an application for at least one assessor to assist whichever judge is appointed to deal with this matter. It was then said that in that pre-trial that they bring an application for assessors timelessly, and that the presiding judge, which is the High Lordship's position,
Thank you, Mr.
decide whether assessors were necessary or not, which is the law, my lord, in terms of the Act. Section 145 is clear on that. So there can be no doubt about that. What then happened, my lord, is that we were told in that pre-trial that accused 11 and 17 have not confirmed that they're ready for trial. I then predicted that the matter would not run. It seemed that there were companies that were also insolvent, as your lordship will get as we go down the list of accused that weren't represented by anybody, not even a physical representative nor a legal representative. We then addressed correspondence about the matter to the state on the 3rd of March 2025. They responded on the 3rd of March 2025. There's an exchange of correspondence by us again on the 10th of March 2025, and we sent them a Section 342A notice. We were told last week, my lord, that accused number 2, whose representative just seen, the previous legal representative wasn't allowed to appear before this honourable court. That person was then removed from court, and that's, I think, what caused the problem for accused number 2. I wasn't present. I followed through the press in my correspondence with Mr. Donation. Mr. Donation then told me on Friday that they were having another pre-trial, and he then sent me a message as a courtesy, and I'd spoken to Mr. Cassim as well, and they informed me that accused number 2 would not be ready for trial, and there's an exchange of correspondence. I also raised an issue with Mr. Donation concerning the relaxation of accused number 3's bail conditions should the matter be postponed for a lengthy period of time, because it seemed inevitable, because I can place on record, my lord, that we are not available in July and August of this year, because we've cleared our diaries and moved everything into July, August, for the remainder of the year. And I'm sure most of my colleagues are in a similar position. So should this matter be postponed, my Lord, I envisage that it will be to, at best, the first term, if not the second term of next year, will be 2026. I need to record that. My Lord, it's the second time this matter has been set down for an entire term. It happened previously. We were meant to run in the second term of 2024, and there were other issues relating to a different co-accused. One was ill, my Lord. One was being extradited, my Lord. I can identify them to your Lordships, so we know the position, but that was the position that we found ourselves in at the time. So the problem that we had is it was clear last year at this time that the matter could not proceed, and it seems that we're in a similar position now, as I had envisaged, and I place it on record, my Lord. And I know the state keeps saying they're ready to proceed, but they haven't ensured, by way of example, that accused number 2's current legal representative has a docket to prepare, or that, and I think there's a similar position pertaining to other accused. I haven't remained in the fold as to those developments, but we are clearly prejudiced by these delays, and I place that on record. As your Lordship already highlighted, it's not the first time, it's the second time, my Lord, that we've set aside a term with tremendous cost implications, and we place it on record, my Lord, that we're prejudiced by these delays. The docket keeps growing. There were amendments to the indictment until relatively recently as well, my Lord, but that's in the nature of things, and there have been further investigations, and Mr. Donation has explained it. So I don't take any issue with the state saying that they're ready to proceed, but I think it goes a bit further than that, my Lord, to ensure that everybody is ready to proceed before one sets down the matter for an entire term for a second time. But that's my position, my Lord. We're on bail. We're ready. They haven't mentioned anything to your Lordship thus far this morning about the appointment of assessor or assessors. But that's the position we find ourselves in.
Thank you, Mr. Houders. Do I understand you correctly that it is mainly because of the problem, or the issue of accused number 2, that you say this matter cannot proceed today? That is the main reason.
No, yes, my Lord, I think they're more accused. I'm not certain that they have problems, because we weren't participating in those more recent trials of last week. But the states are aware of the positions of the other accused. I understand that there were issues relating to accused 17 and others. I don't know, and the position of the companies either, my Lord. In our preparation, we saw from the diary there was some doubt about even dealing with the very next accused, my Lord, accused 5 and 6, as to who represents them in the physical form of a liquidator, trustee, or representative of those companies, and which firms of attorneys. So I don't know if that has been resolved, and that will apply. That's why I'm very pleased, if I might state, my Lord, that we're doing this housekeeping to ascertain who belongs to who and who represents who in this matter. But I can record, my Lord, on behalf of accused 3, 4 and 13, we've set the time aside and we're ready, my Lord, but we envisage that it won't run.
Thank you, Mr. Anderson, and I take it for granted that you are ready to proceed for the rest of this term.
Yes, my Lord. Even in instances, my Lord, where I was offered other work, I said this took priority because I knew of my commitment here. So I've been able, fortunately, when Mr. Donation told me that the matter is not running to full certain days, but this was my first priority and remains so, my Lord, as a commitment to this honourable court. No question, my Lord.
Thank you, Mr.
Thank you.
Thank you. Accused number 4 is also presented by Mr. Houders.
Yes, ma'am.
Accused number 5.
Number 5, my Lord, is Rambau, initials WT, RAMBAU, from Rambau, Maswara, and Chauke Incorporated.
Mr. Rambo.
Rambau, RAMBAU, and his initials are WT. The Lord, I appear for accused number 5, 6, 7, and 8. I wish to bring to the attention of this honorable court that we are ready to proceed with the matter. Indeed, the accused are on bail. We have presented our readiness very early when the matter was being postponed on several occasions. We were indeed ready, even at this stage. Mr. Court.
Thank you, Mr. Rambo. You're not assisted by anybody?
No, I'm not assisted by anyone.
You appear for accused 5, 6,
7 and
8 inches so much.
Thank you, sir. Thank you so much, Mr. Rambal. Accused number 9. Who's appearing to accused number 10?
May it please the Honorable Court, my Lord, I appear on behalf of accused number 9 and 10. And I must put on record that we are ready to proceed, my Lord.
First one, know your name.
Diba TD, my Lord. Diba, D-I-B-A.
Diba.
Diba, TD.
TD.
Yes, my Lord.
Are your clients on bail?
He's on bail, my Lord.
Accused number 11.
Please, my lord, I appear for accused number 11. The surname is Osborne. There's been a change in instructing attorneys, my lord. The instructing attorneys are now Masons Incorporated of Pietermaritzburg.
Initials, Mr. Osborne.
B for Bravo, my lord.
What is the situation as far as accused number 11?
We are ready, my lord.
Is he on bail?
So, Mr. Zulu is on bail, that's correct. We attended a pre-trial at the end of February and indicated our readiness. We did not attend the 20th of January pre-trial as there was, as my mandate had been terminated due to attorneys changing, and my mandate was then reconfirmed by the new attorneys.
Yes, thank you for informing me, Mr. Osborne. Might I just mention that all issues that the accused are raising, and the situation as far as all the accused is concerned is rather volatile because of the enormity of it, as because of the many accused appearing in this case. And what the position was a week or 2 weeks ago would very well be quite different today. That is the reason why I'm going through this exercise now to find out precisely who is appearing, who is still on bail, who is here, who is not here, so that we can assess the situation and then make some informed decisions.
That's what we'll do. Thank you.
Here's number 12.
As it pleases the court, my lord, I confirm that I appear on behalf of accused number 12. My name is Machini. My surname is Mutohu. My lord, the record will reflect that the accused number 12 was initially represented by macro attorneys and briefed Advocate Mazibu. Their mandate has since been terminated, and my services were enlisted on the 3rd of March 2025. Upon receipt of the instructions, I commenced earnestly to prepare for the matter, so as to ensure that we avoid any delays in commencing the trial. I kept the state updated with my state of readiness. To my advantage, my lord, I was previously involved in this matter, albeit representing a different accused. So I'm quite familiar with the matter, including the issues at hand. Wish to place on record that I did not attend pre-trial, obviously on behalf of accused number 12, but I have had a series of consultations with accused number 12 to ensure that when the matter commences today, we are ready. I therefore place on record unequivocally that we are ready to proceed. We are furthermore ready to plead to the charges, and accused number 12 is out on bail. I wouldn't delabor on the submissions made by my learned senior and also sentiments expressed by the Honorable Court in as far as having the matter commencing earnestly and ensuring that the matter is concluded as speedily. And for that purpose, my Lord, I would confirm that I've reserved the entire term to be available to attend to this matter as a court pleads.
Thank you, Mr. McDonald. Excuse number 13.
Lord, that's my other client, which I've addressed to also one. This one.
Mr. Makasile.
There's a lot of please.
Thank you. Excuse 14. Excuse number 14.
Morning, my Lord. A.D. Skuman Stein attorneys, appearing on behalf of accused 14 and 15.
Thank you, Mr. Skuman. What is the type of readiness?
We are ready to proceed. Both accused 14 and 15. Both accused also on bail now.
And I take it that you are available for the remainder of this day.
Indeed, sir. As you please.
Excuse number 16.
May it please the court, my lord, from Skalkwyk, initials CJ, appearing for number 16 on the instructions of Grant Raymond. 16 is on bail. We are ready to commence, reserve the entire term as set out last year, and we would like to report it to Lord to permit me that we will be seriously prejudiced if this matter does not commence sometime during the course of this session. That's my time. Thank you.
Thank you, Mr. Skalkwyk. You mentioned that the accused is on bail.
Yes, sir.
Anybody appearing for accused number 17?
May I please this honorable court, my lord? I am Loiso Macapela. Macapela. L.
Are you ready to proceed?
My lord, if I may just put my attorneys on record as well. Morakile Tebane attorneys. My lord, if I may just give a brief background to our readiness, because in addition to accused number 2, I think we were the other accused that had some problems with readiness. Up until the 20th of January, the virtual pre-trial of the 20th of January, accused number 17 in the criminal proceedings was represented by a colleague. So she was getting representation from me on the constitutional litigation, but from Advocate Makubela on the criminal. He had indicated then, in January, that he was to be ready, or rather he was trying to be ready, but he was not quite sure because he had received the papers quite late. That was in October, and then further papers in November. He then, unfortunately, due to capacity constraints and other issues, had withdrawn from the matter 2 days prior to the 21st of February pre-trial. And that is when I then was briefed to step into the proceedings as both accused number 17's counsel in the constitutional litigation as well as the criminal litigation.
When were you instructed to...
I was instructed the day that Advocate Makubela withdrew his...
That
was on 18th of February, my lord. Yes, my lord. When Advocate Makubela had appeared on the 20th, he had informed the court that the accused number 17 was approaching the Supreme Court of Appeal, appealing the order of this court on her extradition as well as the constitutionality of the state's actions in regard to her extradition. So that is still pending. This is particularly important to note, my lord, because this court, per Yefer AJ, held that the state acted unlawfully and in contravention of international and constitutional law. So the accused feels she has to ventilate that before the Supreme Court to get that order certified. So we wish to place on record that that is still ongoing and that will be a parallel litigation together with this criminal trial. And although one does not depend on the other, the outcome of the Supreme Court of Appeal's decision has a direct bearing on these proceedings as it relates to her extradition. However, my lord, when we appeared on the 21st of February, we informed the state that we were trying as much as we could to get through the 26,000 pages and that we would try as much as possible to be ready by April 15th, which is today. When Advocate Danielshan wrote to the parties on the 11th of April, he indicated that accused number 17's position remained the same as it was on the 21st of February, which was that we would try as hard as we could to make sure that we had perused all the documents and all the necessary information and evidence in order to be ready today. We are ready to proceed, my lord. We just wish to place on record that the Supreme Court of Appeal still is ongoing.
Please inform me what is the nature of the pending proceedings in the
my lord, on in Judge Yefer's judgment, that would be paragraphs 165 and 166. He found that the United States relied on incorrect and false information that was provided by the state to extradite accused number 17. And he said this was a, quote, public interest issue and interest of justice issue, and that the state had grossly infringed international law and constitutional law. Unfortunately, he dismissed the application on the basis that it is the criminal court that should consider those issues and not his court. And that is the basis upon which the matter is going to the SCA, because it was a constitutional challenge, or rather an application for a declarator that the state acted unconstitutionally, and in failing to make that determination, that was an error of law.
What was the nature of the application that was brought before Judge Yefer?
It was a constitutional, an application for a constitutional declaration, my lord.
To declare the extradition unlawful.
To declare the conduct of the state as unconstitutional and invalid, and also to declare the extradition as unlawful, my lord.
You say that Judge Jefer did make a decision or declaration that the extradition was unlawful.
He found that the actions were unlawful and that they contravened, grossly infringed international law and constitutional law. What he said in relation to the extradition, he said the extradition remains in dispute. That was his finding in relation thereto. And that is the basis upon which we approach the Supreme Court of Appeal to make that determination as to that extradition that remains in dispute, and also to make the constitutional declaration that we asked Judge Jefer to make, which he did not.
Is all this happening on the basis of leave to appeal having been granted by Judge Jefer?
My lord, it's happening on the basis of Section 17 of the Superior Courts Act, which empowers the Supreme Court of Appeal to hear an appeal directly from a court of first instance without appeal having been applied to from the court of quo, on the interest of justice point, and on the fact that it is a point of public importance.
When were the matter or the papers due? When was that submitted to the Supreme Court of Appeal?
So that is the issue that we dealt with, my lord, because when Advocate Makubela had to unfortunately leave the case, I had to put the preparation for that appeal on hold in order to fast track the readiness for this matter, because a new counsel would just not have been able to be ready or peruse the papers in time. And so the papers have been completed. The accused has perused everything, and the Supreme Court of Appeal, after these proceedings, or rather after we're done with the readiness with these proceedings, will be approached, my lord. The SCA
has not been approached.
No, my lord, but by the end of this week, the state will have been served, my lord. Everything is ready. The correspondent attorneys are also ready.
Now, say for instance, from your point of view, if you are successful in the Supreme Court of Appeal, what effect will it have on these proceedings that we are sitting with today?
Without dealing with the accused defense at length, my lord, the other point that the Honorable Judge Jefer also made in his judgment was that the accused had the option of using the Section 106 defense of the CPA, which is that this court does not have jurisdiction over to try her offences based on the fact that the extradition was unlawful. And so on the receipt of the declarator from the SCA, that is the bearing upon which it will have here, because the SCA will or will have not declared that the extradition is unlawful.
The such a declaration coming from the SCA, it will mean the end, from your point of view, it will mean the end of these proceedings for your client.
Indeed, my lord.
Thank you.
Thank you, my lord. Could I please have a word on bail? My lord, accused number 17 is the only accused in this matter that has got stringent conditions attached to her bail. In fact, she was the only accused that the state opposed her release on bail. Her particular request is that the stringent conditions be relaxed. She has to report to the police station on Mondays and Fridays, and she has done so without fail every single day, or every single day that she has needed to, from her date of arrest in August, and has not demonstrated any desire to abscond or not to adhere to those bail conditions. However, we feel in the interests of equality of all accused in this matter, we would request this court that those bail conditions be relaxed, and that Ms. Charlotta have the same bail conditions as the other accused, which is that they have none, beyond just their being out on bail, because the continued need for her to report on Mondays and Fridays and to have her whereabouts confined within a specific jurisdiction within the Free State is now, it's obsolete, to say the least. One might understand why it might have been necessary in August. However, in April, with her not having demonstrated any desire to break the rules or to not adhere to her bail conditions, we feel that, and she feels in particular, that continued use or continued bail conditions are too stringent and unfair and not in the interest of justice or equality.
You told the court that you are ready to proceed.
Indeed.
I fact that accused number 17 is ready to plead to the charge.
Indeed, she is, my lord.
You look at section 186 of the Criminal Procedure Act.
Subsection
She
A.
is free to plead that this court has got the jurisdiction.
Indeed.
If the matter then proceeds, then the court will have to find somewhere along the way whether it has any jurisdiction to proceed against it. Thank you. Anything else?
That will be all, my lord.
Excuse me, my please.
Good morning, my lord. Jay Finter from Ulrich Bruin Associates in Johannesburg. Appearing on behalf of accused number 18, my lord. No, it's just Mr. Finter. Attorney Finter. And I'm unassisted. Thank you, my lord. My lord, on the aspect of readiness, my lord, we have confirmed even last year when this matter was set down for a whole term, our readiness back then to proceed. We were severely prejudiced, my client and us as a law firm, that we could not proceed last year, not due to any fault on our side. We've right through attended all the pre-trial conferences and confirmed that we are ready to proceed, that we've been instructed to proceed for the whole term that is supposed to start today. Where we are today, we are ready to plead and we are ready to proceed. I've been reserved for this whole term as well. And if this matter is to align myself with Advocate van Schalkwyk, if this matter is not to start during this term, our client and ourselves will be severely prejudiced going forward.
You're accused on bail?
That is correct.
Thank you, Mr. Finter.
Court, please.
Jason, the court is now fully informed of the state of this trial. We know you are ready to proceed. We know you are not ready to proceed. There seems to be a real problem with number 2. That is the issue of late instructions received only on the 11th, it's a few days ago. My prima facie view is that we cannot postpone this case for a long period of time, as suggested by some of the council. Just for the sake of one or two accused to say they are not ready to proceed. What are your views?
My Lord, yes. The problem with trials of this nature is that one cannot really preempt what is going to happen at the end of the day. May I just take the court back to the beginning of this year, and what we did last year we also did this year. I wrote emails, or had emails circulated to all the parties, asking them, are you ready, are you not ready, what is the position, and so forth and so on. So, I envisaged this problem with accused number 2 quite a while back, because he was represented, and his attorney didn't disclose that to the court. He was represented by Advocate Mazibuku of the local bar. Now, apparently somewhere along the line at the beginning of this year, they picked up problems, and Mr. Mazibuku, Advocate Mazibuku, excused himself from the matter. But then the accused went and instructed a certain Mr. Mogele. Now, Mr. Mogele appeared, God will just bear with me, the 24th and the 25th of March of this year. While he knew that he was disbarred, sucked from the role of attorney. That is why on the 24th, the Deputy Judge President asked him for his credentials. Because I think it is well known by this time that he cannot appear in any court. On the 25th he came, and lo and behold, in some arrogant manner, tried to convince the court that he can appear. Well, I think there is an obligation upon the state, so I had him arrested. But in any event, the arrest is not the main problem. The main problem is the accused was misled. As the Deputy Judge President also said, he was actually conned. Now, of course, that placed him in another predicament. I'm talking about accused number 2. And then he got hold of the attorney that addressed your lordship previously. Now, it is so that the counsel that appeared in this court last Friday shouldn't have taken that brief. But that matter was not further discussed, and the matter was postponed to today. Yes, it is unacceptable, and very much so, because he should have been here to fight his own battles. Now his attorney has to stand in for this mishap, may I call it that. But the problem is, where does that leave accused number 2, in all fairness? And that is for this court to decide. I'm in total agreement. In all fairness, I think he should get a remand or postponement. I'm talking about accused number 2. But not until August or whenever. I think a reasonable time on which the court will have to decide what is reasonable. And may I just say, this docket is not 26,000 pages, it's a lot more. But in any event, I'm glad they at least read up to 26,000 pages. But I should think, in all fairness. Otherwise, we're gonna pick up huge problems in the SCA, which is it speaks for itself. If the court bluntly denies a postponement for accused number 2. But not a carte blanche. What the state is saying, give him a reasonable postponement. And the time is in the hands of the court. But I suggest not more, and I'm very adamant about this, not more than a month. Any attorney or counsel that works hard can prepare this matter in a month. There's a lot of reading, yes, but as I said previously, there is a voluminous and all-encompassing forensic report. If you read that report with its annexures, you basically know the state's case inside out, because it takes everything together. It's basically a summary of each and every averment against these accused. It is a lot of reading, but it's a very nice summary. One of the reasons why we appointed the forensic auditors. That pertains to accused number 2. Accused number 17 is a different kettle of fish. I find it very strange that my colleague stands up here this morning and says that they are ready to proceed with this criminal trial. I'm saying this because they were one of the team of defense attorneys and advocates that did not answer to the mail that I circulated. That is why I called Mr. Dibani, the instructing attorney, last week. He didn't answer my call. He called me back the next day. And I specifically asked him, what is the position? You didn't answer me. Are you ready, or is it still the same position as what it was in February? And I'll tell the court what they placed on record in February. That what my colleague said is not correct. And he told me last week, as in Thursday, that they will not be ready. And they will not be ready anywhere in this term. That is why I sent another mail informing all the other parties of the predicament of accused number 2 and the problems with accused number 17. So the state was misled. It's as clear as daylight. What my colleague furthermore says, that they placed on record in February that they will do their utmost to be ready for today is false. She said pertinently, and we can look at the record, they will not be ready. They will not be ready because it's too much reading, too much preparation, counsel has changed, and. So, my remarks were, afterwards, that it is a pity that the presiding judge postponed the matter then and there to today, instead of just giving another pre-trial date to hear how far they have prepared. But, so it hanged in the air. I'm very surprised and, of course, glad that they are now ready to proceed. It takes away half of the issue. But I'm just worried about the ethics. Pertaining to these applications that they lodged, and there's not only one, I'm going to ask my colleague, Advocate Fries, to address you on that, because it is motion applications in nature, and she handled it on behalf of the state. But again, what my colleague indicated to the court is not correct. And that's a worrying fact. But may I ask my colleague to address you on that issue. Because I think it's very important what the position is with that application to the Supreme Court of Appeal. Because that's one of the factors that this court will have to consider today. Thank you.
My Lord, before Ms. Fries addresses you, may I just make one observation, my Lord. My Lord, as far as accused number 2 is concerned, it is significant to point out to your Lordship, at the relevant time and at the present time, he is the manager in charge of chain management policy. Your Lordship knows in the main matter, the contention of the state is a contract was given for over 250 million. 250 million was paid. Further subcontracted for 5 million. Greece subcontracted for 23 million. All wasted. The very man who's in charge of procurement, my Lord, with great respect, procures an attorney who struck off the roll. The same person, when your Lordship is assessing reasonableness, when he's informed, but your attorney is struck off the roll, procure counsel who is not available. And the address by my learned friend for accused number 2 is really an affront to the dignity of the court. My counsel is briefed, who is not available to run the trial, knowing the prejudice to 17 other accused, knowing the overwhelming prejudice to the fiscus and the public at large. My Lord, I would submit to your Lordship, when you're assessing reasonableness, my Lord, nothing stops your Lordship from managing the trial to say, we can start the trial to the extent that the prejudice in preparation at the relevant time, your Lordship can stand it down. The difficulties, my Lord, my Lord, the accused hasn't procured a counsel who's available today. But your Lordship will take that into account. I had to make that point in the public interest.
Thank you.
That's your Lordship.
Physical keys, my Lord. In respect of the interlocutory application for a declarator about the constitutionality of the extradition of accused 17, the judgment of Judge Heerfer that my learned friend referred to was handed down on the 23rd of January 2025. As my learned friend has informed the court, there was no application for leave to appeal pursued in respect of that judgment, and that remains the position today. My reading of Section 17 of the Superior Courts Act, as well as Section 16, makes that compulsory before an application to the SCA can be proceeded with. That has not happened. To the extent that my learned friend has now told the court that there is no pending application before the SCA as we stand today, that is correct. The state has not received any such application. If an application were to be pursued, it would be well out of time by now. We're nearly 3 months later from that day. We have informed through correspondence, which would have happened, I don't have the dates unfortunately with me, but in February after the judgment was handed down, that the correct procedure would have been to apply for leave to appeal. That was seemingly ignored. We were informed by the attorney for accused 17 that they are preparing the record for the Supreme Court of Appeal, but that is of course incompetent procedure under the Superior Courts Act without leave having been granted. In short, as we stand today, there is no pending application for leave to appeal. There is no pending application before the Supreme Court of Appeal, and there was no finding made in the judgment of Heerfer as to unconstitutionality or unlawfulness. In fact, at paragraph 171 of the judgment, the learned judge said, presently, however, it appears that the constitutionality and therefore the lawfulness of the extradition of the applicant remains in dispute. That is as far as the judgment went, and as my learned friend stated, the application was dismissed with cost. So, as we stand today, there is no pending application before the Supreme Court of Appeal, and the state will submit that that would not be or ought not to be a reason to grant a postponement or delay the matter insofar as that accused is concerned.
Thank you.
May I just, something that I neglected to tell the court. There is the issue of this assessor that the state wanted. We already informed the Judge President as in the end of last year that we are intending to request or apply for an assessor to assist the presiding judge. It's only my colleague Horace that addressed this issue to some extent, but I know there was opposition from Mr. Horace as well as from Mr. van Skalk. To put it bluntly, I put some lines in the water in the meanwhile to find out the availability of assessors. I was specifically looking for possibilities in the sense of persons that were retired and so forth. I couldn't find anyone retired at this stage. But what worries me, my Lord, is whether we are ever going to get an assessor, because of the fact that the state or the Department of Justice only pays R1,000 a day. I must say, when I got that mail from the office manager in this court, I found it hard to believe, but apparently it is a fact. So I don't know who in his right mind will be prepared to work for R1,000 a day, and that's before tax. So if the court now today decides that this case, this trial should proceed, which is of course the first prize for everyone, especially the state, then I intend to withdraw my application for an assessor, because I don't think, first place, we're going to get one who's going to be prepared to appear or sit with your lordship for say 750 rand a day. So yeah, that's, and of course this is going to take weeks and months, even years. So I think the practicality thereof, even a retired person will not be prepared to appear for those fees.
Yes, Mr. Mason, if you say to me that you are withdrawing your suggestion that an assessor should be appointed, then there is no need for me to go further into that case. But looking at section 145 of the Criminal Procedure Act, it seems to me that if there is a request now that an assessor be appointed, that request is premature, because section 145 clearly says the following, namely, an assessor for the purposes of this section means a person who, in the opinion of the judge who presides at the trial, has experience in the administration of justice and so forth. But subsection 2 provides as follows: where an Attorney General arraigns an accused before a superior court, firstly, for trial and the accused pleads not guilty, or for sentence or for trial and the accused pleads guilty and the plea of not guilty is guilty. So it seems to me the question whether an assessor should be appointed will only become relevant after the accused has pleaded not guilty.
Yes.
So to make such a request or to make such a suggestion before any of the accused have even pleaded is, in my view, simply premature.
It is a question, my Lord, I absolutely hear what your Lordship is saying, but it is a question of trying to preempt and to avoid a delay, a further delay, because if I stood up today for the first time informing the High Court of the Free State Division that the state intends to ask for an assessor, it would have come as a surprise and would have most definitely caused a delay, which it now in any event will cause. But what I'm saying is, if the court grants a postponement to accused number 2, and it is for 3 weeks or even 2 weeks, the court can still make the determination that the court wants an assessor. We are of the view it can be of assistance to your Lordship, but it is ultimately your Lordship's decision. If your lordship feels that an assessor is not necessary in this case, then so be it. And I also indicated previously to other presiding judges that we will not pursue it any further. If your lordship makes a ruling that, listen, I don't need an assessor, then it's the end of the matter. But if this matter is postponed, the court can make that final decision and decide. But what I'm saying is, if the court denies or refuses any postponement on behalf of accused number 2, then I don't want the case to be delayed because of an application for an assessor. Then, in those circumstances, I shall withdraw my application. Everything just to get this trial running. That is the the bottom line. But the application is now there. If the court decides the court wants this assessor, then so be it, and it's going to cause a delay.
Can I just add? Can I just mention this information? There was a suggestion, there was talk of the state suggesting the identity of an assessor, and I believe that the state says that, or said that, with the intention to assist the court.
Yes.
But let me say it quite straightforward. I'm not likely to take any suggestions from the state as to the identity of the assessor. That would make the accused feel uncomfortable.
Of course.
And I don't want to happen that. I want this court to provide them with a fair trial before this case. So if the decision is there in the end, or in the beginning, that an assessor should be appointed, then it is the presiding judge who should decide on that. And then the presiding judge should also take into account, as it was stated before, the enormity of this matter. I do not think, having regard to all the evidence that will be read, the fact that there are 18 accused, I will of the view that this matter will take many months, if not more than a year or 2 years, to bring to finality. And to bring in an assessor in such a complex, long matter that could last very long. At this stage, I'm really not inclined to appoint any assessor and to make a ruling that this matter should proceed as we said today.
100%, my lord. That is why I just want to clarify. That is why I specifically stated in the papers when I applied formally applied for the appointment of an assessor that it is the decision of the court, and if an assessor is appointed, we'll only make suggestions. What I said was when I threw out the lines hypothetically, it was just to test the waters. Will someone be prepared? And I haven't found one that will be prepared. So, but if I understand your lordship correctly, now the assessor issue has been disposed of.
Yes, I think I must bring finality to this issue.
As it
I make a ruling now.
Yes.
The court will proceed sitting with one judge as it is now. No assessors or assessors will be appointed.
100%. Thank you, ma'am.
There's a note before we proceed further, and that is there is apparently an application by some of the accused that this court should find that there was an unreasonable delay on the part of the state in the prosecution of this matter. For that reason, the charges against them should be squashed. Are you aware of it?
No, I'm not. But it's been the narrative all along. And I have stated it ad nauseum We were ready last year. We were even ready before that. In April last year, when the trial was set down, accused number 17 had not yet been extradited from America. But we were prepared to carry on without her. Then one accused had to be hospitalized and another had some problems and so forth. So, very important. And this is very important to note, that the state was not the reason for the remand in April 2024. That is the reasons why we circulate these emails, to ensure that everybody is right, or is ready. How the state can be blamed for an attorney appointing an advocate on a double brief, I don't know. I fail to see. It is so convenient to blame the state for each and everything that happens in this trial. That is why I specifically said, because I'm waiting for that kind of response. Yes, the state now arrested an attorney. The poor accused number 2 is now, we left him without an attorney. The fact is, my lord, he wasn't in any event going to be able to appear in this case. So, how the state can be blamed in each and every instance, I don't know. But rest assured, and this is extremely important, if the court denies this request for postponement, I put the charges to the accused immediately. Especially now that the assessor issue is out of the way. And directly thereafter, if there's not some other applications or whatever, I call the first witness. That is as simple as that. Is where we are. That is how ready the state is. And we were in this precise position last year in April. The only difference now is that accused number 17 has been extradited, and she's now part of the trial. So everybody's here and everybody's ready except accused number 2.
Yes, thank you, Mr. Dumas. Can I just find out, are there any of the accused who wants to proceed with this application for the finding that there was unreasonable delay on the part of the state? Are there any of them?
My Lord, we had submitted that application as to Lordship refers to on behalf of accused 3 and 4. It was premised, my Lord, on the basis of the state at the very late stage, in December last year, proposing assessors. Your Lordship has dealt with that matter, so I consider it has been discharged and final, and we will not be proceeding with it any further, my Lord. If I can explain our conduct, my Lord, what happened was we had numerous pre-trials, as I said to Your Lordship. I can give Your Lordship the dates, I don't believe it's necessary. At no stage was the appointment of assessors ever canvassed. I, with respect, agree 100% with Your Lordship in relation to the stage at which assessors ought to be appointed in terms of Section 145. That's after the plea of not guilty or after the plea of guilty and before sentence is imposed. It isn't going to be the case here, fortunately. So we're looking with respect, as I understand, to pleas of not guilty. They haven't occurred as yet. We had numerous pre-trials. There was no mention in any of those pre-trials of the appointment of an assessor. It arose late. I understand that matter is discharged, and we will not proceed at this stage with any 342 application premised on that. I also need to confirm as an officer of the court that everything that Mr. Donation informed Your Lordship, he kept us abreast of through the process, my Lord. We were kept abreast of all the process of who was ready, not ready, and as he explained it to Your Lordship, how it was explained to us. We were of the view, my Lord, that the introduction of the assessors would cause a further delay. If that's been abandoned, we abandon the matter.
Thank you. If I may, we've also filed a notice, the Lord will remember, that has now been underpinned by the developments, and in fact, my Lord had conducted inquiry today through the process that we've done now in the premises that become superfluous. It's not proceeded. Thank you.
Yes, gentlemen, I must inform that I've looked at this matter carefully as well as I could, and there can be no doubt that we as any delays in bringing this matter to where we stand today. There were delays on the part of the state, but I'm of the opinion that can be explained, having regard to the enormity of the case, of the many charges, the many accused, and the complexity of the case. This isn't the type of case which the state can be expected to bring before the court in a week or 2 weeks' time. On the other hand, there were many delays caused by the accused themselves. In some instances, those delays caused by the accused were not the fault of themselves. And in the premises, I formed the opinion that we cannot, we should not waste time to point fingers today to any delays. And therefore, I appreciate the attitude of Mr. Hodis, also contact from the perspective, to let go of the application for the finding that there was unreasonable delay. Then the particular section says, if it appears to the court that there were unreasonable delays, and from the beginning it didn't appear to the court that there were unreasonable delays. So I regard that matter as being put to bed, and we will not proceed any further with that issue. Now, there are basically primarily two accused who say that they are not ready to proceed. But it is my view that this case must proceed. We cannot postpone, and in 2 months' time we sit in the same position, and in 6 months' time we sit in the same position again. That is not in the interest of justice, and it's not in the interest of the accused themselves. I'm therefore of the opinion, and I will ask any of the council who wants to comment on it, and therefore of the view that we should, as a next step, now proceed with putting the charges to the accused one by one and let them plead to them, so that the lines can be drawn and that we can work on that forward. Accused number one, his legal representative, Mr. Piper, has informed the court that they are ready to proceed, for instance. And what I would prefer to do is to ask Mr. Mason to put the charges to accused number one and to but then, when we come to accused number two, I do not see the necessity for any legal representative of accused number two to have an opportunity to study 26,000 papers in order for him to plead. All of the accused must plead in terms of the provisions of Section 106. That is, if he's guilty, if he's not guilty, or that they have been found guilty of specific charge previously, and so forth. It is a simple question as to what they plead. And as far as accused number two is concerned, Ms. Mahona, you can certainly, and I will give you time to do it, I will give you half an hour if you need it, to approach your client accused number two and ask him what the plea will be. Is there a plea of guilty? Is there a plea of not guilty? So that I can enter that plea and that we can then move forward from there. Do you need any opportunity to consult with the accused number 2?
Yes, my lord. Yes, my lord. We will need the opportunity to consult with the accused number 2.
Yes, and as far as accused number 17 is concerned, Mr. Makapela.
Ms. Makapela, my lord.
Sorry. Your accused is the one who seems to rely on future findings on the Supreme Court appeal. But after having heard his pleas on behalf of the state, I want to confirm with you that there is presently no application for you to appeal to the Supreme Court of Appeal on behalf of your client.
My lord, I think we were quite clear with that, which causes confusion as to why Ms. Fries felt the need to inform this court once again. But we did clarify that there is no application, and that the reason for that is because we had to set that aside to prepare for this case, but that would still be going ahead because after all, there are applications for condemnation. And so that is indeed the case.
Thank you, but Ms. Makapela, that would not, for instance, preclude accused number 17 to plead not guilty on the basis that this court doesn't have the jurisdiction.
Not at all, my lord, not at all, which is why we informed that we are ready to proceed.
Yes, thank you. The court will then adjourn for half an hour. Let us make it 12 o'clock. Then we will proceed with the plea